Eileen, can you give us a quick overview on Senate Bill 245?
I sure can. Good morning, Mr. Chair and members of the committee. Senate Bill 245 would enact the Kansas Grid Resiliency, Innovation, and Dependability Act, which would allow the Kansas Corporation Commission to authorize the approval and issuance of energy transition bonds in order to recoup certain costs related to a retired, abandoned, or soon-to-be abandoned energy generating facility. Senate Bill 245 would enact 14 new provisions of law and amend KSA 66-1239 and KSA 2020 sub 84-9-109. Section 1 of the bill provides the citation to the act and defines the key terms and phrases used throughout. Section 2 of the bill enumerates the specific requirements and information that flows between the Commission and the electric public utility during the utility's application process for the financing order. This section describes the information that must be included with the application, the criteria that the Commission uses to determine whether or not to issue a financing order, and the elements that must be included in a financing order. Section 2 also discusses the Commission's actions that go into effect once the energy transition bonds have been issued and the duties and responsibilities that fall upon the public energy utility after the Commission issues the financing order. Section 2 also specifies that the Commission may engage a financial advisor and counsel as the Commission deems necessary, with attendant expenses associated with retaining such advisor and counsel added to the financing costs of the energy transition bonds. Finally, Section 2 provides for judicial review for any adversely affected party. Section 3 states the limitations placed on the Commission with regard to matters relating to the financing order, energy transition charges, and energy transition bonds. Section 4 specifies how energy transition charges are shown on customer electric bills. Section 5 states that the nature of energy transition property specified in a financing order constitutes a present intangible property right or interest therein. The section also provides that all or any portion of energy transition property specified in a financing order issued to an electric public utility may be transferred, sold, conveyed, or assigned to a successor or as assignee that is wholly owned by the electric public utility and created for the limited purpose of acquiring, owning, or administering energy transition property or issuing energy transition bonds under the financing order. The bill also provides that if an electric public utility defaults on any required remittance of energy transition property specified in a financing order, a court shall order the sequestration and payment of the revenues arising from the energy transition property to the financing parties or other insolvency proceedings with respect to the electric public utility or its successors or assignees. Section 6 describes the security interest that is created, perfected, and enforced in the energy transition property to secure the principal and interest and other amounts payable with respect to the energy transition bonds and other amounts payable under other ancillary agreements and other financing costs. The section lists the conditions under which the security interest might be created and states that the security interest attaches without physical delivery of collateral or other act. And upon filing of a financing statement with this Office of the Secretary of State, the lien of the security interest becomes perfected against all parties having claims of any kind in tort, contract, or otherwise. Section 7 states that any sale, assignment, or other transfer of energy transition property shall be an absolute transfer and true sale of such property and not a pledge of or secured transaction relating to the seller's right, title, and interest in, to, and under the energy transition property if the documents governing the transaction expressly state that the transaction is a sale or other absolute transfer other than for federal and state income tax purposes. The section lists the conditions under which a transfer of an interest in energy transition property may occur, the factors that will not affect the characterization of the sale, assignment or other transfer as an absolute transfer and true sale, and the conditions under which a transfer of an interest in energy transition property might be enforced. Section 8 states what must be included in the description of energy transition property. Section 9 states that financing statements are subject to certain provisions of the UCCC and that financing statements shall be effective from filing until termination without the need for continuation statements to be filed. Section 10 is a choice of law clause stating that the laws of the state of Kansas shall govern over the validity, enforceability, attachment, perfection, priority, and exercise of remedies with respect to the transfer of an interest or right or the pledge or creation of a security interest in any transition property. Section 11 provides that energy transition bonds shall not be considered debts of the state, and neither the debt nor any political subdivision thereof shall be liable for such bonds. Section 12 provides for who may invest in the energy transition bonds. Section 13 states that the state shall not take any of the actions listed in the section, essentially pledging not to impair the value of the energy transition property, the energy transition charges, or the rights and remedies of bondholders, assignees, or other financing parties. Section 14 states that the electric public utility has sole discretion to determine how it expands or invests the proceeds received from the issuance of energy transition bonds. Section 15 amends KSA 66-1239 pertaining to electric generating or transition facilities and the determination of rate-making principles and treatments. Senate Bill 245 would amend subsection C of the statute to require that prior to undertaking the construction of or participation in a generating facility or prior to entering into a new contract, a public utility may file an application with the Commission for a determination of the rate-making principles and treatment as proposed by the public utility that will apply to the reflection in wholesale or retail rates of the costs to be incurred and the cost savings to be achieved by the public utility in retiring such public utility stake in the generating facility, including but not limited to the reasonableness of such retirement. The Commission will then issue an order setting forth the rate-making principles and treatment that will be applicable to the public utility stake in the generating facility or to the contract in all rate-making proceedings on and after such time that the generating facility is retired. Section 16 amends KSA 84-9-109 pertaining to the scope of Article 9 of the Uniform Commercial Code. And the amendment to the statute would add the creation, perfection, priority, or enforcement of any sale, assignment of, pledge of, security interest in, or other transfer of any interest in, right, or portion of any interest or right in any transition property under the Kansas Grid Resilience, Innovation, and Dependability Act. And with that, Mr. Chair, I can stand for questions.
Committee, are there questions at this time? Senator Peck.
Thank you, Mr. Chairman. I'm going to guess that because of the fact that Senate Bill 245 has been introduced, this is a departure from the normal or historic method of bonding or financing for a utility company. Is that correct or not correct?
I would not. I don't believe there are securitization statutes on the books currently. And that would be why we're creating new law. Yes.
I was doing my best to pay attention, and you covered a lot of ground. Is there any wording at all in the bill that if there are any savings, significant savings to the utility company, that a portion of it be passed to ratepayers at all? Or probably not, but I thought I would ask that.
I don't think so, Senator, but that may be a better question for a representative from the utility.
Thank you. And that's one reason that I ask that, to because I want the question out there for someone to answer. Last question that I do have for you, in section 16, there's some bolded words. Usually, we don't have bolded words, to my understanding, until after, and these are at the beginning of sections, or I'm sorry, it's subsections, but, so what, can you answer, I guess I've never seen bolded words in a bill like this.
Senator, some statutes, and this is the Uniform Commercial Code, some statutes are formatted like that just to kind of use section headers and call attention to breaks in the sections. The Uniform Commercial Code does that. The several of the compacts, interstate compacts, do that. It happens a lot with codes that apply across jurisdictions so that we cannot amend them to our drafting protocols. And that's why you're seeing them like that. And the bolding actually does confuse us as revisers at times, because we look at it and ask the same thing. What are we amending and why does it look like this? But that's actually formatting of the statute that we did not touch.
Okay, well, I appreciate that, because I was confused as well. Thank you, Mr. Chairman.
Senator Gossage, did you have a question?
I do, Mr. Chair, thank you. Along those same lines, I'm seeing italicized sections cross out, but if this is new law, I'm trying to understand why that is the case.
Senator, can you point me to the specific?
Yes.
Instance?
On page 21, line 26, line 33.
Okay, that's actually a current statute. And if you look at that, if you back up on page 21 to page 20, it's section 15, amending KSA 66-1239. So that's an existing statute.
So they're saying we're amending this statute as part of this new bill.
Correct.
Is that correct? Okay. It's an insertion of this statute. All right.
Correct.
And then my final question, and I'm not sure if you can answer this, Eileen, if it's permitted from you, Mr. Chair, is this is financial institutions, and this Evergy is not a financial institution. I'm curious why this is not appearing before the Energy Committee.
Eileen, I can take that.
Thank you, Mr. Chair.
The Senate President decides which committee bills go to, and since this is a financing instrument, he sent it to us. Seeing no more questions, we will now turn our attention to the proponents. Committee, we have 8 people testifying today, so I'm going to ask everybody to keep it for 3 to 5 minutes. I'm also going to ask committee members to keep your questions pertinent to Senate Bill 245. As much as we'd like to talk about the weather and gas prices and electric prices and rolling blackouts and that type of thing, those have nothing to do with this bill, and we need to get through where we're going today. So if we can keep our questions to Senate Bill 245, I'd greatly appreciate it. First person we have is Chuck Casely, Senior Vice President with Evergy. Welcome, Chuck.
Morning, Mr. Chairman. Thank you for having us this morning. Ranking Member Holscher, appreciate it. Members of the committee, I apologize for my voice. I've been in more press conferences over the last 72 hours than I think I've done in the previous 20 years of my career. So if I'm a little ragged, I apologize. Appreciate the opportunity this morning to talk about the Grid Resiliency and Innovation and Dependability Act, and appreciate the fact that I testified actually three days last week, I think, in front of the Utilities Committee, and we ended up having severe weather and temporary power outages. So I'm really glad to be in front of financial institutions this morning. I don't know if there's a correlation, but I'll take the change of scenery. So this legislation really just is very straightforward. I know there's a lot of pages to it and a lot of sections, but I'll talk about several parts and what the intent is. The intent is just to create bonding authority such that utilities could take assets that have really reached the end of their useful life, but still have a significant amount of depreciable capital in them and a depreciable life left, and bring them to a good conclusion for customers and for the utilities. And we'll talk about a little bit how that works. And while it certainly impacts our operations as we look forward over the next 10, 15, 20, 30 years, this really isn't a policy bill. It's just, it's seeking to get authority for a financing mechanism. We are a very capital-intense business, and nothing is more expensive to invest in and maintain and run than our large power plants. Some of them cost as much as $2.5 billion. If you're talking about a coal facility, $1 billion for a large natural gas plant, and when it comes to a nuclear facility, it can be multiples of even that. We're talking about huge capital investments that have 30, 40, 50-year depreciable lives. And what happens is, as you continue to age, as those assets continue to age, you have to continue to invest in them. Maintenance cost goes up, and many cases, fuel costs go up. And as a result, the depreciable life just keeps getting tacked on and tacked on and tacked on until a 30 or 40-year asset can be running for 50, 60, 70 years, which is fine. Many of these power plants still make electricity, and certainly we used every single one of them that was up and running this last week. But as we look to the future, there are opportunities to save money. There's opportunity to provide cleaner energy, and there's opportunities to do those things if we didn't have the incentive to keep these things ongoing and used and in service, meaning that we can only recover the balance of what we've invested in these plants if they're being used, which creates the incentive to keep them running even if there are cheaper or cleaner alternatives out there for our customers, which is where this bill comes in. It would create bonding authority that would allow us to issue bonds, take those plants out of rates by the, when you issue those bonds, the proceeds would go to the utility, take the plants out of rates, and then invest in something that would be cheaper and cleaner on behalf of our customers. So for example, we have a couple of power plants right now that are smaller in size, that are between 50 and 60 years old, but still have rather large balances of capital investment that are depreciating. Instead of doing a big environmental retrofit on one of those plants, instead of doing extensive capital investment year after year after year to keep those plants going, in many cases, you would save on fuel, you would save on future emissions, you would save on transportation costs, you would save on staffing costs, and most importantly, if you retired them, they would come out of rates for our customers, which has a return on equity of about 9.3% associated with it right now, and replace that 9.3% with bonds that are closer to 2-3%. So you've got interest savings, you've got maintenance savings, you've got capital investment savings, you've got staffing savings. And from an environmental perspective, if we invest in renewables, whether it's solar or wind turbines, or even if we invest in natural gas, the emissions profile of the replacement generation that might be needed at some point would be considerably less than running some of these older, less efficient power plants. The way this essentially works is the utility would form a special purpose entity. That entity would issue bonds. The proceeds of those bonds would go to the utility. The utility would then take that asset out of customers' rates and put on the bill and assign a right to recover through the bill, the bonds that folks have invested in. Again, there would be a savings of somewhere between 5 to 7%, depending on the issue price of the bonds for customers. There are really just 4 parts of this bill. Lots of sections, lots of pages, but we got to reach into a lot of different places to put this together. The first is just setting up securitization and making sure that that securitization is something that can only be sought by the utility, meaning there aren't other parties who can force the utility to try and retire a coal asset or a gas asset or a nuclear asset. We have to seek that authority through the commission, and it's voluntary on our part. Of course, it would be subject to a full proceeding at the Kansas Corporation Commission. The second thing is that the utility, once they get those proceeds, has the sole discretion on how to reinvest them or what to do with it. The third would be a predetermination that retiring a facility is good. This, again, would be a proceeding in front of the commission that would allow for all stakeholders to weigh in and talk about whether this is a good thing, but it would also shield the utility from making a decision that then in retrospect could be looked back on and criticized. And then the final thing is just final part is really just legal language to make everything in compliance with the Uniform Commercial Code. I'm trying to be brief because I know we've got a lot of folks here today. I'd just really like to say one other thing, which is we've worked very, very carefully and closely with the Kansas Corporation Commission staff on this legislation. The intent is really just to create a financing mechanism that can save money. And so what you have before you today is the collective effort between us and them. Having said that, we agree with them and we agree with many of the other conferees today that one of the most important things, if not the most important thing of this bill, is that it drops cost savings to the bottom line for customers. There isn't a reason to do this without those cost savings. And we are still working on language with staff that would cover that and put it specifically into the law. This is a fairly complex mechanism, and we're not quite there yet. We've actually got some time set aside with them later today or tomorrow, and we're going to continue to work on it. In summary, it's a tool for financing, saving money. 50% of the states in the United States have this, and you still have to go through a full process with the KCC. I look forward to any questions the committee may have.
Chuck, thank you very much. A couple of points. There is no doubt that this is a cost-saving measure for ratepayers in the future. But I also, for those of you who have not served on utilities in the past, there is a very fine line between legislative duties, which are not necessarily rate-making, and the KCC. So we want to make sure that we both stay in our lanes. We don't want to get into KCC's business, and we don't want KCC into ours. So this truly is a financing instrument, and then future rate cases will be determined by the KCC. Am I correct in that?
That is absolutely correct. And obviously, Mr. Chairman, there are, you've got taking assets out of rate base, you've got maintenance costs and all sorts of things to be considered. We want all those contemplated. We believe the right place is with the KCC.
Thank you, Chuck. Committee, are there questions? Senator Hildebrand.
Thank you, Mr. Chairman. I have two, if I could be allowed. And Chuck, thank you for your testimony. I am one of those that have never sat on utilities, so I'm going to try to stay in my lane, but if I get out of it, just say you're out of your lane. So you, in your verbal testimony, you said when it is cheaper or greener. So is there ever a time that if something was greener, but not cheaper, you would still do this?
So, Senator, that's a great question. One of the things I described, one of the parts in here means it can only be we can only ask for this bonding authority at the behest of the utility. The reason that we do that is because we know there's lots of stakeholders to the process at the KCC. Some are very interested in renewable energy. Some that's their number one, variable that they optimize to. We have to balance everything, and for us, reliability and cost are the two biggest things that we have to do. We do want it to be cleaner. We do want less emissions. But no, we would not want to invest in something that was more expensive, that was going to cost more than functional assets that we have working, which is why we think it is very important that we be able to bring it forward and request it and not have other parties say, you need to do this.
Thank you. And my second question is, because I'm not on utilities and I'm not real familiar with the way rates and everything are figured, so that's not my question, but you had mentioned that the lifespan of a facility is 30 to 50 years, but your bonding is past 30 to 50 years. So this, by doing it, I'm just trying to make sure I understand the concept. I always relate it back to things I understand, like my home. If I refinance my home, I understand what that is and stuff. So can you kind of relate how going past the 50-year lifespan and the bonding and you said something like 9.5% versus 2 to 3%. A little bit more detail on how that works in this instance.
Absolutely. So in order for us to recover something that we've invested in, it has to be used and useful for our customers, which means it has to be operational. And so let's say a power plant had a $100 million price tag when it was built in 1980. Now we're sitting here 41 years later, but every year we continue, and let's say it had a depreciable life of 50 years, and so there's 10 years plus or minus that's left on that. Problem is, almost every single year we invest, it's not like a car, right? We invest a little bit more, adds to what the undepreciated balance is, which means as long as there's an undepreciated balance, we have an incentive to keep that in rates and keep using it, even though there might be a cheaper alternative out there. What this would allow us to do is take whatever the undepreciated balance is, if it's 10 years worth or 20 years worth, total that up. Let's say it's $100 million, and we would take that out of rates. That in and of itself would have a reduction to, that would help with rates. And then what we do is it'll come back in, right? But we'll issue bonds and we'll work with the KCC to determine how long those bonds should be. Should it be 10 years? Should it be 20 years? Would it help to smooth it out a little bit more? Essentially like refinancing. The difference is, though, that the interest rate will be significantly less. Then the issue that we're still dealing with right now is what do you do with all the other things like fuel costs, staffing costs, things like that? How do we make sure those get reflected in rates as soon as possible and prudently as well?
Wilson?
Thank you, Mr. Chairman. Previous securitization bills have mandated renewable spent. This one doesn't. Can you talk about that change and some of the others might mean?
Absolutely, Senator, and thank you for the question. Again, we believe and are in the middle of investing significantly more in renewable energy. Right now, about 50% of the electricity that we deliver to our customers is carbon-free from principally Kansas wind and our nuclear plant in Burlington, Kansas. Having said that, what we don't want to have happen is interests that have one goal and one goal in mind, which is carbon reduction, drive the process through a financing mechanism. And so we believe that if we can make energy cleaner, we want to do it. We also want to make sure it's more affordable. In many cases, like wind energy, wind is more affordable and it's cleaner. That doesn't mean that we can go to all wind energy today, as we've seen over the last 3 or 4 days. Beg your indulgence, Mr. Chairman. We have gotten some benefit from our nuclear, our coal, and our gas plants. And so, again, it's not that we wouldn't invest in renewable energy. It's just that we don't want this mandated, the proceeds from the bonds of retiring a coal plant have to go to a particular form of energy. That still has to be between stakeholders, the KCC, and the company in the context of a proceeding at the KCC.
Do you need securitization for your STP bill to be successful?
Our Sustainability Transformation Plan, no, we don't. There are no plans currently that we would require to have securitization in the next 4 years. That said, we do have several older coal plants where we could consider doing something like this. Again, it's not necessary for our Sustainability Transformation Plan that we've announced, but this is a tool you want to have. This is a golf club you want to have in your golf bag, right? You may not use a 3-iron, but every other time you play golf, but every once in a while, if it's there, you're glad you have it.
Thank you. Appreciate it. Let's turn our attention to Zach Pistoria with the Kansas Sierra Club. Hi, Zach. If you can keep it to 3 minutes or so.
I'll try my best. You cut me off whenever. Can be long-winded sometimes. Thank you, Chairman, members of the committee. I was planning on testifying before you virtually today, but at the last minute, I thought it'd be nice to look you directly in the eye. We think this is one of the most consequential pieces of legislation you can pass this year and for the years to come. We think there's a lot of benefits, as you heard, for cost savings to ratepayers, but also for our energy future here in Kansas. Zach DeStora, proud lobbyist for the Kansas Sierra Club. We have over about 5,000 members across the state of Kansas, nearly in every corner, and dedicated to protecting the great outdoors. We've been supportive of securitization legislation for the last 3 years, but I believe there's kind of a time and place for everything, and I think the time and place is here and now. Just with the events we've seen in recent days, it's pretty clear to me that there's a fundamental need that we need to prepare for extreme weather events in the future and harden our electrification system going forward. So thank you for being in front of this committee, especially because y'all understand the importance of financing and what that can do for development and progress for our state. You'll see my testimony has the green tree in the front. I'll let you read some of the specifics, but you understand that securitization is an important voluntary, low-cost capital tool to allow for investment in lower-cost energy resources and immediately achieve savings for rate-paying customers. Roughly half the states across America have this securitization enabling legislation. It's been used in 65 transactions across America, totaling $51 billion. Just a few examples. Duke Energy used it to close down a nuclear plant in Florida that was estimated to save customers $700 million over 20 years. Just recently in New Mexico, they wanted to close down a coal plant's $361 million securitization deal that would achieve customers $7 a month savings on their bills, investing in 1 gigawatt of renewables and storage. So that's just the general highlights. I want to note that London Economics was the top recommendation for them. Y'all helped enable that study. Let's take their suggestion for helping lower rates in Kansas. One piece, I think the gist of everything. Coal plants are costing us right now. We use our coal plants, Evergy's coal plants run less than 50% of the time, but yet we're still paying 100% of the costs and more because of that return on equity. We have analysis that we've lost $267 million over a 4-year span. And if I may, just one last point. I think we can fine-tune this legislation as it goes along, but let's get the car down the track. I think there's also a point there that we rely on the honor system for the utility to go ahead and apply for securitization. But you remember the legislation passed in 2014 for the Kansas Energy Investment Act. Some of those programs that were approved by the regulatory agency never came through, and those were low-income weatherization programs that we surely could have benefited from today. So overall, we support the legislation. We encourage you to pass the legislation, and we can work it, fine-tune it along the way. Thank you.
I appreciate it. Committee, we will now turn our attention to Ashok Gupta with NRDC.
Thank you, Chairman. Can you hear me?
Virtual, I believe. Yes.
Great. I can start my video, but I don't think my video for some reason is working, is it?
It's okay. If you can keep your testimony to 3 minutes or less, that'd be helpful.
Happy to do so. First of all, thank you, Chairman Longbine, and thank you, members of the committee, for providing this testimony in support of SB 245. We've been very involved and interested in securitization for the last 3 years here and 4 years in Missouri, and have worked on securitization policy around the country. As Mr. Casely said, over 20-some states have this and have used this as a way to save consumers money. This is primarily about saving money for customers. That is the underlying key statement that we need to all keep in mind. And it is a financing tool. It basically allows you to access bonds at 2 to 3% compared to the utility cost of capital. And that is why we think what that allows you to do is make other investments that need to be made. So it's a combination of retiring certain assets, making other investments, and saving consumers money. I've provided written testimony that provides some of the specific answers to questions you might have. As Zach just mentioned, 2 years ago, the legislature asked for a study to look at the costs of Kansas, and securitization was mentioned as one of the primary tools that should be available to help address costs in Kansas. And legislation is now available for you to support to actually achieve cost reductions. And as Mr. Casely also said, KCC staff has been very involved, and you'll hear from them. They are still working through some details on the exact language around those cost reductions, but the mechanics of how securitization works is what most of this bill is about. 99% of the bill is just the mechanics of what the bond markets are looking for these bonds to be issued. The other key point is nothing about these bonds affects the state or any municipal government's bond ratings. This is not a state-issued bond or even a utility-issued bond. This is going to be a financial instrument created by the KCC that helps make this transition possible, and that's why it's being called as the transition bond. The only other point I would like to make is, Evergy last year was not in support of the bill, and KCC wasn't either. So there was a lot of work was done over the last year to have both Evergy and KCC come on board. They both supported the concept. It made sense, but the specifics of the language and the legislation was very important for both Evergy and KCC to now come on board. And that's why I think at this point, we are all supportive of this bill and wanted to move forward, because if we get this tool in our toolbox, it'll help deliver some of the things that the legislature has wanted, which is lower cost for customers. The only thing I will conclude with is we've seen what's happened in the last few days. Utility investment in the grid is super critical to achieving the resilience and reliability we want. Freeing up assets that are currently tied up is key to being able to make more investments. So this is about also making the investments in things we want to make investments in, and not have our investments tied up in assets that we may no longer need and are expensive and we're paying for. So if we want to both have cost reductions and make the new investments that are needed for reliability and resilience, securitization is a tool that lets us do that. And this is why 20-some states have it, including some very, Louisiana, Arkansas, they've been using this for actually storm cost recovery. Michigan, Wisconsin, New Mexico and Colorado passed it last year. I just testified at a hearing that Minnesota is having on doing this there. So this is a tool that people are looking to have in their toolbox, because it allows us to access low-cost financing that creates real value. And there are very few things we do in policy sometimes that create real value, but this creates real value that we can then use to decide how to make new investments and how to have clear consumer benefits. Thank you for the opportunity to talk today to you. And if you have any other questions, I'm happy to answer them. This is something NRDC and I have been working on for, around the country for almost 25, 30 years, and have a lot of experience on this topic from elsewhere.
Thank you very much for your testimony. Committee, let me call your attention to proponent written only testimony from Curtis Sneddon with the Topeka Chamber of Commerce. We'll now turn our attention to the opponent testimony. Hopefully we'll have time for questions afterwards. First up is Robert Vincent with the Kansas Industrial Consumers Group and Kansans for Lower Electric Rates. Welcome, Robert.
Mr. Chairman, members of the committee, good morning. Robert Vincent for KIC and Clear, which is a consumer advocacy group of the Kansas Industrial Consumers Group. I'll keep my remarks short, that way other members can get to us. We are not opposed to securitization whatsoever. We are opposed to Senate Bill 245 in its current form because we see fundamental flaws with this legislation that are going to negatively impact ratepayers. And we think that we can take the time to get this in a place that's workable and beneficial to utilities and to customers. The goal of securitization is to retire underutilized utility plants, save ratepayers money, and reinvest those funds. But that needs to have material benefits to the ratepayers that are ultimately going to be the parties paying for these bonds. And right now, that standard in this bill is elusive. We just don't see it. You have to remember, these bonds, once they're issued, they're going to become irrevocable, non-bypassable, and they're going to exist for decades. We need to take more than a couple of minutes discussing the pros and cons when we're talking about such a complex piece of legislation that folks will not be able to escape. And think about that for a moment. There are hundreds of thousands of Evergy customers that might be subject to this someday, and some of them get behind on their bills. How much are they going to have to pay when the time comes that they need to get service restored? Is it just their energy bill, or are they going to have to pay for the charges, the energy transition costs that these bonds result in? We need to think about that. And is Evergy going to become a debt collector because they're the ones ultimately servicing these or collecting those funds? These are critical issues we've got to talk through that we just haven't had the opportunity to do that. There is an incredible sense of urgency that we have to get securitization on the books in Kansas. You have time. The events of this week indicate that any discussion of retiring a plant is going to be tabled. SPP was capacity deficient this week. We had rolling blackouts. There will be national and state investigations into what caused this issue, how we need to study it, how we need to mitigate it before any plants are retired. You have time on your side to get legislation that works well not only for utilities, but works well for Kansans. And my last issue or remark I want to say is we support the securitization. We don't support this bill. And at times, our group pushing for lower rates can become at odds with utility companies. But I want to tell you right now, stand committed, that we will work with the utilities, with stakeholders. We will sit down and talk through all the issues that we have in this bill and work to come up with a compromise package, a total package that's good for utilities, that's good for Kansans, that's good for ratepayers. That's my commitment to you, and we stand by that. Finally, we want to extend our thanks to all the utility personnel, linemen, electricians, pipe fitters, you name it, who have been working tirelessly to keep the heat and the lights on over the past week. They certainly are in our debt, and we owe them a great deal of gratitude. So thank you, Mr. Chairman. That concludes my remarks.
Let me call your attention to opponent written-only testimony from David Nickel with CURB and Ernest Kuntley with AARP. Now we'll turn our attention to neutral oral. First, we have Justin Grady with KCC. Justin, I believe you are virtual.
Yes, Chairman Longbine, of the committee, good morning. My name is Justin Grady. I'm Chief of Revenue Requirements, Cost of Service, and Finance with the KCC. Just a quick note on my audio or video quality. If I get choppy or garbled at all, Chairman, please interrupt me and I'll turn my video off so that the audio is uninterrupted.
Will do.
Okay, thank you. Staff, our written testimony is neutral on this bill, but if you look at the written testimony, we indicate clearly that we're supportive of the concept and actually supportive of 99% of the bill as it currently sits. We have been involved in discussions over the last several months with Evergy and with CURB to get this bill to where it exists today. Really, we're at the, we're within the 5-yard line on the football field in terms of we have a few specific mechanic issues to discuss with them regarding when the rate credits would go back to customers, the timing of that, how that would affect bill volatility, and whether or not all of those cost savings would go back all at once or be smoothed out over a short period of time. And that's, I offer an amendment to the bill in my written testimony, which indicates where we stand today. My understanding is Evergy and CURB are on the same page in that we're going to continue to work together to figure this out. The language that exists in the bill today is not specific with regard to the mechanics of how the savings would go back to customers, but it's clear that the KCC could not approve a securitization application unless there was substantial benefits to customers. There's language in the bill like mitigate rate impacts and that the net present value of savings would be greater than otherwise would be the case with the financing. I won't go over a lot of the other, I won't repeat the other benefit or the other testimony that the other conferees offered this morning, but a few quick things. So I spent, and members of the other members of the KCC staff spent significant time since the last legislative session reviewing in detail the legislation of states of New Mexico, Colorado, Montana, Florida, West Virginia, and North Carolina, and several other states, not to the same level of detail. And as a result of that due diligence, I'm confident today that the bill in its current form, Senate Bill 245, contains all of the appropriate mechanics and financial structural elements that would allow this to be a useful tool that we could use. Two other very important changes that are in this bill, and I think it was Mr. Gupta that mentioned we were opposed to securitization in each of the last two sessions, and it was just because those bills weren't quite where they needed to be. The two very important bills that ultimately of the vast majority of the language in this bill is, one, the KCC has to approve any retirement through that 66-1239 process before, as a prerequisite to where the utility can't even file an application for securitization until we approve any retirement that would want to be securitized. That's critical because in that application, we would evaluate the economics and the reliability and whether or not it was a good thing for Kansas. And so only if we approve the retirement, then it moves forward to a securitization. And then lastly, and critically, the utility in this bill would have the flexibility that it just puts the onus and the legal requirement back on the utility that says you have the obligation to provide efficient and sufficient service. And so if you retire a plant, what you replace it with is your legal responsibility, and the KCC will approve that when it occurs. But we don't, in other words, we don't restrict the replacement of any potential future retirement to only a particular fuel source or fuel type. And I think I agree with the other conferees that, you know, if anything, if the last 5 days has taught us anything, it's that diversification and flexibility is key. And so anyway, those are the reasons why we stand supportive of the vast majority of the language in this bill. I appreciate the opportunity to appear before you virtually this morning, and certainly would be willing to stand ready for questions at the appropriate time. Thank you.
Thank you very much. Committee will now turn our attention to Dorothy Barnett, who is the Executive Director of Climate Plus Energy Project with the Clean Energy Business Council.
Hello,
Dorothy,
Chairman.
are you with us?
I am. Are you able to hear me okay?
I am, but I've only got about 7 minutes left. And
I only need 2.
All right, perfect.
Chairman Longbine, committee members, thank you for allowing me to present neutral testimony on 245. I'd like to say that we actually do support securitization, but there are a couple of key issues we have with this particular bill. I'm glad that Justin mentioned Colorado and New Mexico. One of the key elements that those bills have that we don't see in the current bill is a requirement for least cost resources that can be added to the utilities portfolio. Those least cost resources generally start with energy efficiency. As Zach in 2014, KIA legislation was passed, yet Kansas still does not have energy efficiency programs, especially for low and moderate income. We'd like to see a way that cost savings from securitization could be invested in low income, moderate income energy efficiency programs. As Senator Olson noted, previous versions of this bill specifically called out renewable energy investments and least cost supply side and demand side resources. That's not in this bill. However, if we were just going to consider the least cost investment, that would be appropriate in our minds. So I'm pleased that the KCC is refining this. I hope one of the things that they're going to be looking at is how do we ensure that any investments made for retired assets are indeed least cost, because we know that renewable generation and energy efficiency is the least cost generation source today. Lastly, HB 2381, a state energy plan bill introduced this week, would stand up a task force to create a state energy plan. You know, my question is, would it make more sense to take the time to include all stakeholders in the conversation around securitization through that process? Again, we heard Mr. Casely say earlier that securitization isn't needed for implementation of their STP, their Sustainability Transformation Plan. So can we take the time to ensure that we're getting it right for the utilities, for Kansas ratepayers, for our environment, and our economy? We hope to be able to participate in any conversations to ensure that we can make those things happen before this bill moves forward, and hope to be able to support it once some of those changes can be made. Happy to answer questions and appreciate the time this morning.
Dorothy, we appreciate your testimony. Committee, I want to turn our attention to Phil Wages with KEPCO.
Good morning, Mr. Chairman, members of the committee. I am Phil Wages, Director of Member Services, Government Affairs, and Business Development for KEPCO. KEPCO is Kansas Electric Power Cooperative, also known as KEPCO. KEPCO is a not-for-profit generation and transmission utility, providing the electricity needs of 16 member rural electric cooperatives encompassing approximately 2/3 of the state. As stated before, securitization is not a new idea, not a new concept. The first bill, I believe, was discussed in 2019. However, Senate Bill 245 is considerably different and thus warrants significant and thorough scrutiny. Evergy has spent a considerable amount of time in developing the language and considering the parameters of the bill, and rightfully so. That is a prudent and necessary business practice, particularly for utilities. However, other potential affected entities, such as KEPCO, have not been afforded the same amount of time, given that the bill only became available to us last Thursday evening. And the relationship between KEPCO and Evergy is twofold. First, we are one of Evergy's largest wholesale customers. We purchase approximately 30% of our energy requirements from Evergy. And secondly, we are joint owners in 2 generating facilities, the first being the Wolf Creek Nuclear Generating Station, and the second being Iatan 2, which is a coal-fired facility in Weston, Missouri. As both a significant customer and co-owner, KEPCO is asking for additional time to review and analyze the bill. We began reviewing the bill when we got it last Thursday evening, and we've been continually reviewing the bill ever since. Even the 4 days when we went through the energy crisis, we were still reviewing and analyzing the bill. Providing us 5 days to review such a complex financing bill is not an appropriate amount of time to assure KEPCO and our member owners that the bill will not have a negative impact to our member owners. Mr. Chairman, we respectfully ask for additional time. I know that that does not fit into the parameters of turnaround, but we are working on this as quickly and as diligently as possible. And that concludes my testimony, and I would stand for questions.
Thank you. Appreciate it. Eric Stafford with the Kansas Chamber. I haven't seen him. Okay. Let me call your attention to neutral written only testimony from Whitney Dameron with Liberty Utilities and Leslie Kaufman with KEC. Committee, unfortunately, we're out of time. I know Chairman Olson's got a committee meeting coming in here right away, so we will close the hearing on 245. Dean wanted me to let the committee know that she does have a couple of amendments that she needs to add for drafting purposes, and that we may be anticipating an amendment from Evergy also. So we will not meet tomorrow. We will not meet on Monday, and we will meet on Tuesday morning. We are adjourned.
You're right with me.